Uh, Welcome, everyone. This is the July 23rd, 2025 Special Magistrate hearing, and it's time to get started. So, Madam Clerk, do you want to read the announcements, please?
Yes. The purpose and function of the Jacksonville Beach Special Magistrate hearing in accordance with Florida Statutes, Chapter 162, and the City of Jacksonville Beach Code of Ordinances is to reach an equitable expedition to enforce the codes. The city presents the violation and evidence to the special magistrate. Next, the property owner is sworn in and responds to the violation and evidence. Both the city and the property owner may call witnesses to provide sworn testimony relevant to the case. This is a quasi-judicial hearing, not a public forum. Individuals not called as sworn witnesses will not be heard.
Thank you very much. And I see Ms. Beavers will open case number 24-267. The property owner is Des Luna, LLC.
Yes, good afternoon, Special Magistrate. This case was a continuance from our June hearing in regards to a non-conforming sign. The business had been unoccupied and vacant and did not display a message for over 180 days. As you can see in the picture, this is the sign. And this was it. And as of July 23rd, the sign has been removed, so this case can be closed.
Okay, thank you very much for that evidence. Based on the prior order, the non-conforming pole sign was deemed discontinued, and the respondent was required to remove it no later than today. And it obviously, from the photograph Exhibit C, you're showing that the sign has been removed. I will issue an order finding that the respondent has complied and close the case.
Thank you.
Okay, thank you very much.
All right.
Well,
Okay.
I should have asked just to stop for a moment. Is there anyone here to speak on it? Just to make sure.
I don't think they're
Okay,
today.
I just wanted,
Okay.
I should know that, shouldn't have done that. But, yeah, so there's no one here to speak on this particular one.
No, and I need to be sworn in.
You need what?
To be sworn in.
Oh,
Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
and would you just confirm that the testimony you gave previously on case number 24-267 was the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you.
Yes, sir. And your name?
Nikki Beavers Walker, City of Jacksonville Beach Code Enforcement Officer.
Thank you.
Okay. All right.
Thank you. Thank you, Ms. Beavers.
We are moving to the next item on the agenda is for parish rentals. This case was also for a non-conforming sign. The business had been closed for over 180 days.
Excuse me, just for the record, Ms. Beavers, the information that you had just on the screen a moment prior says it's case number 24-291.
I'm sorry, it should be 24281.
24281. Okay, thank you very much.
And under section 34-450 non-conforming signs, like I said, this business had been closed for more than 180 days. As you can see, it was Seahorse. It was formerly Seahorse Floors. This is the sign. And in Exhibit C, which isn't a good photo, but the sign has been removed.
Okay, thank you.
So my recommendation is to close this case.
Okay, thank you. Is there anyone here to testify in regards to parish rentals, case number 4-281. Seeing no one, we'll close the public hearing portion. I agree with the recommendation, and will issue an order finding that the respondent is in compliance and closing the case.
Okay. All right, moving right along to case number 25303. Property owners RHC Associates, doing business as Dunkin' Donuts at 1325 Beach Boulevard, section 34-450 for non-conforming sign. This sign was damaged. The last verifiable year that the sign was intact was back in 2022. As you can see, the top half of the Dunkin' Donuts sign has been damaged and has not been up there since 2022. It would be more than 50% of the cost to repair the sign, which is also a non-conforming sign, and where the city is asking that the sign be removed and be replaced with a monument sign. Right now, the property is in transition of change of ownership. I did get a call from the owner today stating that I'm not sure if it was the buyer or the current owner that is ill. So
That is what?
that they're ill and they wouldn't be able to attend today. This was a continuance from the June hearing. They were to present estimates of how much it would be to replace the previous signage, or if they were going to just remove it. My recommendation would be a $250 per day fine until the sign has been removed.
Is there anyone here to speak on RHC Associates case number 25-303? Okay, please come forward. And for the record, please provide your name, address, and be sworn in by the clerk.
My name is Walter Amaral. My address is 601 First Street South, Unit 6C, Jacksonville Beach, 32250.
Do you swear or affirm that the testimony you are about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Emerald, you may proceed.
I was hoping, I don't know how this works, but I was hoping we could get a continuance on two problems. One, Mr. Patel is not able to be here today, and this concerns him more than it does me because he's responsible for the sign. And secondly, we were not able to get the pricing in within the amount of time that we were given. We did reach out to them, and they are working on it, and we're within days on getting these numbers. We could email them to you, or we could, if we could do it another day, we could do it another day. So I that's what I was hoping to do here today, is getting a continuance.
Could you tell me why you weren't able to get the estimate?
Not enough time, ma'am. Not enough time?
Not enough time?
Yes, ma'am.
But you said at the prior hearing that it was enough time. I believe, as I recall, you said that it was enough.
I probably did say that, ma'am, but it just wasn't. I'm not the ones who... I assumed there'd be enough time to get the prices, but it wasn't.
Is there anything else you want to say about
No, ma'am.
the situation?
No, ma'am.
Your Honor, can I ask who was the company that you're...
I'm sorry, you have to speak into the microphone because...
was there a particular company that they had already contacted?
But I don't. Kevin contacted the companies,
Okay.
and I don't know who he. I can get that to you today.
Okay.
But I don't know who they are standing here right now.
Okay. Your Honor, our next hearing is scheduled for August 27th. If the property owner can get that information to me prior to that hearing, then that way we'll have that information by the next hearing.
So, I appreciate that very much, Ms. Beavers. I'd like for the city to have that information about a week before August 27th to allow the city to review it and provide it, quite frankly, provide it in their notice to me
Yes, ma'am.
when they send the agenda packet to me.
Perfect.
I don't know, that would be August 20th,
Okay.
would be a Wednesday, correct, Madam Clerk? And I believe that if you do not, I think I'm going to issue an order that if you do not have that estimate in by then, that you'll be potentially subject to the $250 fine starting that day.
Absolutely.
Now, I see Mr. Popoli wants to add something. You need to be sworn in, please.
Please state your name.
Christian Popoli.
Do you swear or affirm that the testimony you are about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
So that's Christian Popoli, senior planner. The director and I had a conversation about not only this sign, but other signs that have been discussed in enforcement cases. And her interpretation of the code has always been that a sign is a single unit. So in this case, the sign itself was damaged, and this question of 50% doesn't really apply in this case because, again, it is a non-conforming sign. It's been partially destroyed, and it can't be re-erected or relocated. So I know your thoughts were that it was the 50% question, but the director, as the person who is legally entitled to interpret the code under the city's ordinances, number 2 is the thing that they were cited for originally and the thing that they should be considered under. So I think it's really just a waste of everybody's time to go through the cost evaluation because it is a non-conforming sign. It was damaged and it can't be re-erected.
Okay, this is completely, new information to me.
Well, it's the
I
thing
don't
that
have
we've been
anything.
arguing about for the last few
Excuse me,
hearings.
I wasn't finished. I don't see anything. Can you point to something here or is there a written interpretation? Because I'm looking very specifically at 2A and 2B. And remember, non-conforming signs are allowed to remain in existence unless something either under 2 or 4 causes them to become no longer legally non-conforming. So I don't, could you tell me how this interpretation or what in number 2 points to that direction?
It is a legal non-conforming sign that is no longer erect, or at least a portion thereof, and it can't be re-erected.
Well, my understanding is that they are not requesting to re-erect it. In fact, the order that I signed last time was that the city was amenable to allowing the existing sign face to remain and to be updated with a change of copy for the Dunkin' Donut business, provided no structural alterations are required, and provided the existing vertical poles on either side of the existing sign face are reduced in height to match the top of the existing sign face. So are you saying that the city is now pulling back from that, what that offer that the city made on at the last hearing on June 25th?
No, what I'm saying is that regardless of what the cost is, it's really a question whether they want to amend this sign or they want to build a new sign. The order intent was that the sign would be a monument sign when they were done, regardless of how it was done.
But this portion of the sign has not been damaged.
Right.
This
no,
portion of
I
the
get that.
sign has not been, you know, you're, so I don't think that they're even asking to re-erect the upper portion.
That was my understanding last time, was that they were asking for that.
Yes,
Are you
ma'am.
asking to still re-erect the top portion?
Yes, ma'am. We were going to look at both ways, re-erecting the top part or changing the reader board or the marquee to a Dunkin' Donuts sign.
Well, even this section has the 50% or more, Mr. Popoli, under C. It says any non-conforming sign shall be removed or rebuilt in full conformity to terms of this division if it is damaged or allowed to deteriorate to such an extent that the cost of repair or restoration is 50% or more of the cost of replacement of such sign.
Correct. And number 2 says that a non-conforming sign shall not be re-erected, relocated, or replaced unless it is brought into compliance with the requirements of this division.
Right.
So
And
they can't re-erect it. But if they choose to cut the poles down and leave it, that's, I think, their decision. I don't think it affects the city's stance that, regardless, they can't put the sign at the top of those existing poles any longer.
I think that they're saying the same thing, and I think the 50% still applies.
I don't. I think they're saying they want to put the sign back at the top, and we're
Right.
not amenable to that.
And that would require a 50% analysis.
Like I said, the director disagrees that it is a non-conforming sign and
Well,
can't be
she's not
re-erected.
here. I can't ask her any questions.
I mean, she is here.
Oh, you are? Well, then why are you? Then I don't
I'm her
understand.
designee. I can speak on her behalf.
No, actually, you can't.
Our code says I can.
No, actually, well, maybe in some other setting other than special magistrate setting. So if you'd like to come forth and speak on this and tell me why you consider it to be one unit.
If you don't mind, thank you very much. Thank you, Heather Ireland, Planning and Development Director. I concur with everything. Oh, I'm so sorry.
Monica.
Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do. So it is the goal of the city to get rid of all non-conforming pole signs, of which this is. The sign was damaged in a manner that the structure is no longer there. The cabinet that held the message is no longer there. We historically do not allow those on non-conforming signs to be re-erected, reconstructed, or replaced. It's one sign. It's not two signs. It's one sign with two separate components. It's got the permanent sign and their variable message sign, which are allowed. You're allowed to have that, two separate components to one sign. But because this has been damaged and it's non-conforming, our stance, like everything Mr. Popoli said, is that it cannot be re-erected or replaced unless it is brought into compliance. Now, I know at the last hearing, there was discussion of making this conforming. That would be totally fine if it met the requirements of a monument sign. So they can have I think it's a 30-inch base. The variable message component can be 50%, but there are height and size limitations. So we haven't seen any indication that any effort has been made to determine or figure out how this sign, keeping some of the components of it, can be made conforming. If they're able to do that, we can issue them a sign permit that shows they're changing this into a conforming sign. But right now, it is not a conforming sign. It has been damaged where it's not even, if the cabinet's not even there anymore. If the copy had blown out, they could have just replaced to that, but the whole structure of a portion of the sign is gone. So our interpretation is that it needs to be either entirely removed and replaced or somehow transferred into a conforming sign.
So let me ask you a question. Last time, there was a decision by the city or an offer by the city to allow what I just read, to allow the poles to come down to the height of the existing cabinet, and for, provided, and I'll read to you exactly what was in the order, allowing the existing sign face to stay and to be updated with a change of copy, for the Dunkin' Donut business, provided no structural alterations are required. And what Mr. Popoli referred to was electrical kinds of things that, as long as nothing needed to be changed. And provided the existing vertical poles on either side of the existing sign face are reduced in height to match the top of the existing sign. Is that, in your opinion, does that meet the monument sign requirements that you just referred to?
Possibly, but we haven't seen any evidence that it does. Again, we
Well,
need
which
to
part?
see
What evidence are you looking for? Because
that what they want to do will
typically-
conform. There are height limitations, there are width
Well, we know
limitations.
the height. You know the height. We're
This
talking
does
about
not conform to the current sign standards.
this being that picture.
That whole thing, that whole structure does not comply because it is considered a pole sign. We don't allow pole signs. We allow monument signs currently. And we have only allowed monument signs since before 2010.
So, if I may ask another, I want to go back to my first question. If they were to agree to what I just read, which was specifically exactly what the city said that they were amenable to at the last hearing, is that satisfactory in your opinion?
Again, possibly. We haven't seen how they're going to turn this sign into a conforming sign. If they can convert this into a conforming sign, then absolutely
What
yes.
do you think needs to be done to convert it into to make it
I just
conforming?
told you it can only have a base of a certain height. It
Well,
cannot be vacant between the ground and the bottom of the sign. And this piece of the sign can only be 50% of the entire sign, which has size, height, and width limitations. We need to see
So
those
you know-
details.
So isn't it up to the city to tell the applicant, the respondent, and the special magistrate whether or not this sign, as described at the last meeting, at the last hearing, you know what the height is, you know the size. I don't understand why you're not prepared to tell.
We can tell them the requirements in the code. I don't know how tall this sign is. I can tell you it's
Actually,
taller than me, but
why don't you know? Why don't you know? If
because I
you're
have not
bringing-
measured it. I can
But-
tell them what the requirements are. They need to turn in a building permit to us showing that their new sign, the conversion of this to a monument sign, meets our code standards.
So you put the special magistrate in a very awkward position. The city has done this by first offering up, and basically what seemed to me was an offer to try to find a resolution. And now you're saying, in fact, that might not even meet your requirements.
I don't know if it does. I haven't seen proof that it does or does not. That's what
That's what I
I'm
said.
saying.
I
So
said-
we are happy to work with them to say, here are the requirements that you need to make this sign meet.
So
That's
why
what we
didn't
do.
that happen this month?
I don't know. I wasn't involved in this process until today, or this particular case until today. So I can't speak to that.
Okay.
I don't know
I'll
that
ask
they've
Mr.
requested that
Popoli,
from
'cause
us.
Mr. Popoli and Ms. Beavers were. So why didn't that happen this
Because
month?
they would have needed to submit a sign permit with, like Ms. Ireland stated, that showed with the estimates the specifications for the sign. They have not done so yet.
So that wasn't raised at the last hearing. There was never any mention of
I
a building
believe
permit
so.
being submitted.
It was stated because in order for them to redo the sign, they would have had to obtain a building permit. And Mr. Popoli, I recall, stated that we may or may not approve it.
He specifically said that it would be provided no structural alterations were required.
Yeah, but
I
they still
didn't-
would have needed to submit a sign permit.
Magistrate, if I may, if they're going to alter that physical structure of the sign, at a minimum, the building official would need to review it to make sure it's structurally sound.
Of course, I understand
That would be done
that.
through a permit process.
Well, yes, I understand that, but the point of coming back today was for everybody to determine whether the whether or not that was amenable to the respondent, the offer from the last meeting. But now it seems like even if they said it was they agreed to it, the city is saying, well, it may not be possible anyway.
They didn't provide that evidence today, and that was also stated that today they were to provide that evidence, and we have not yet received that evidence.
I would like to, since you are here, and since Mr. Popoli started this conversation based upon the fact that that you said that you consider the interpretation of number 2. Could you tell us, where in number 2, and I'm referring to 34-450, subparagraph 2, where do you understand that, or what evidence do you have, or how is it that you interpret this structure sign to be a single unit, when in fact we know that it had 2 sign faces and it's got 2 pillars, and that the one face continues to exist? And just help me understand that. Present whatever evidence it is that you want me to take into consideration.
The code allows 1 monument sign and previously, prior to 2010, 1 pole sign per property. This is 1 sign, regardless of how many messages are on there. It's 1 sign. This sign was non-conforming and it is partially gone. So we are considering this non-conforming sign basically discontinued, and it may not be erected, replaced, or relocated. That is our interpretation. That is my interpretation as the sole person permitted to interpret the code, and I designated that authority to Christian to move forward with this case. So again, we are very happy to provide them the standards so that they can work with a sign company to bring this sign, if they can, into compliance. But we haven't, to my knowledge, been asked to have a meeting with the property owner to go over what he needs to know to be able to work with a sign company to bring this sign into compliance with the current code. Cost is irrelevant at this point. It's a non-conforming pole sign, and it either needs to go or be brought into compliance, which again may be possible, but we haven't seen evidence of that one way or the other.
So why do you think that subparagraph C is not applicable?
About being cease to exist for a period of 60 days. I want to make sure we're on the same page.
No, I'm under paragraph 2.
C, non-conforming sign. I mean, this could apply, but we are applying number 2. A non-conforming sign shall not be re-erected, relocated, or replaced unless it's brought into compliance with the code, which may be possible, but we have not seen evidence of that yet.
That's if it's damaged.
It has been damaged. It blew down in a hurricane. The whole cabinet's gone.
Okay, let me put it this way. Your code says any non-conforming sign shall be removed or rebuilt in conformity to the terms of this division. If it is damaged or allowed to deteriorate to such an extent that the cost of repair or restoration is 50% or more of the cost of replacement of such sign, you've already said it's partially damaged.
Yes.
And that's why you believe that it's no longer a legal non-conforming
Correct.
sign. However, to reach that, you have to establish that the cost to repair or to restore is 50% or more.
I'm considering it gone, so it cannot be replaced. It is the sign is gone.
Well, that's very hard for me to believe in light of the picture that I'm looking at.
You know what? In 5 years, they'll have to replace it anyway because we have a provision for all non-conforming signs to be gone in 5 years.
That's fine, but
So
we're
we would
not-
like them to come into compliance with the code so they don't have to come back in 4 years and pay another however many dollars for a new sign, because it will be what's going to happen.
And
We
the-
can work with them to bring this sign into compliance if they give us the information we need to do so.
I definitely appreciate that, and I think that, you know, from a business judgment perspective, that would be a very wise thing for the respondent to take into account. If I was the owner, I would certainly be thinking about that. Do I want to invest in the restoration of this sign if I'm going to have to take it down in 5 years, or do I want to take my chances and restore it, because I don't believe that it's or I don't believe that the cost to restore it is going to be 50% or more of the cost to replace it. That's outside our decision, or
Certainly.
at least my decision.
It's
Okay?
also my job to interpret the code, and that's what I'm doing. No one else in this room. It's mine.
So I still don't understand why you don't believe that this paragraph C is the 50%.
Because that's my interpretation, and it doesn't matter because we haven't gotten that information anyway, even if we were going to use that.
Well, that's true, but it's hard for me to. I've just heard that, you know, that we're willing to go to August 27th. We've talked about requiring the respondent to submit this information by August the 20th, so that you and Mr. Popoli and Ms. Beavers all have a chance to review it, possibly with maybe even with the respondent, and with this estimate, both the estimate and the proposed, what it would look like, you know, with the dimensions. So, you know, I have a hard time just ignoring subparagraph C. And also have a hard time believing that the sign is no longer, you know, is no longer in existence. So I think that my ruling today is going to be to go along with the idea of the August 27th and the August 20th submittal of the information, no later than that. And we will come back on August the 27th. It's not what I wanted. I was very specific in my order last time. I want the competent evidence to be presented. If they don't believe that it's 50%, then you, Mr. Emerald, need to bring competent, substantial evidence before to present as evidence. I want to see that evidence submitted by August the 20th. We've been doing this. I think is this the third hearing, Ms. Beavers?
Yes.
Yes. And that's more than enough time. The first time, quite frankly, I gave the respondent
60 days.
60 days, the very first hearing. I gave 60 days, and then I gave 30 days. So you've had 3 months. And that's even since we've been hearing this matter. So, in my opinion, that's more than enough time. I'm not going to give you any more time. August 20th is it, and I believe that that's more than fair, quite frankly.
Magistrate, can I ask a quick question?
Yes,
Is it possible for them to provide the dimensions of the existing sign as part of that?
I'm sorry.
Can they provide the dimensions of the existing sign as part of that information?
Yes, actually, I would expect him to provide the dimensions, and because how is he going to provide us with the evidence that shows the 50% or more? Quite frankly.
Well, and also the question of whether they can bring that sign into conformity. I think that would answer that.
Exactly, in order to show one way or the other. So, do you understand what it is that I expect to see
Yes, ma'am.
on August the 20th?
Yes, ma'am.
Okay, let's go over that so that all of us are in agreement. First, we want the estimate, and I want to point to you specifically 34-450, subparagraph 2C. That's one portion of the evidence that I think that you need to bring forth. Then, in addition, I think that it's necessary for you to bring the dimensions of this existing structure, and in particular, the dimensions of the height of the existing cabinet, and I guess we also need not only the height of the cabinet, but we also need the dimensions of the cabinet
That
itself.
should be included in the quote.
It should be, but it may not be. I want to make sure that it is.
Okay.
Okay. And then I think that August the 20th is going to be the deadline. And I will see you back here on August the 27th. And in the event that you do not comply, I'm going to put into order that the $250 day fine will begin accruing against the property. And, I believe that everybody has tried to work with you, and also the potential buyer, and enough time has gone by so that I will not entertain any further extensions after August the 27th.
Okay, thank you.
Thank you. Thank you to each of you for being here to testify. I appreciate that very much. It's important that the city and you, Mr. Elmer, present testimony for me to hear and be able to make a decision based upon the evidence that's before me. So thank you. Okay,
Thank
can
you.
we move on to
Yes. All right. Next we have Austin Surf Shop. This is up under Millennial Property Owner Millennial Trust Company LLC. This is in regards to a damaged non-conforming pole sign. No, I left it. I think I'm printing two of the wrong thing. This sign has been, I think, the evidence.
the evidence was,
the
if I
last
may,
time,
that it was deemed discontinued at the last hearing.
yeah, on the paper that you have, it also gives a date. I printed the wrong thing. The last time that it was an actual sign up, I think it was either 22 or 23 that the last time my actual message and sign was on the pole.
Well, the information in your report says that February 2021 was the last
Okay.
verifiable date
Yes,
before it was damaged.
correct.
And let me see if we at the last hearing, Mr. Popoli testified that based on Google Maps, the subject pole sign was damaged as long ago as April of 2022.
Yeah, the last time that we actually saw
and-
actual sign was February 2021 off of Google Maps.
A sign face. Okay,
So
that
this
makes sense.
This falls up under section 34-450 under B4, sign structures that remain vacant, unoccupied, or devoid of any message or display a message pertaining to a time, event, or purpose that no longer applies for a period of 180 days shall be deemed to be discontinued. It also falls up under 4D, that removal of the discontinued non-conforming sign shall include all sign support components, angle irons, poles, and other remnants of the discontinued sign that are not currently in use or proposed for immediate reuse, as evidenced by a sign permit application for a permitted sign. As you can see, as of today, that the pole still remains.
Okay, thank you. And just as a reminder, it was determined that the sign is deemed discontinued. I made that determination. And that the respondents testified that the front yard was too small to accommodate a meaningful monument sign, but had no survey. They had no survey or any other evidence to support that statement. I allowed the matter to be continued until today to allow respondent to present evidence to support the statement that a monument sign is not feasible. That doesn't that the only reason for that was to allow them to come forward with that statement. It does not mean that the pole can remain. The pole cannot remain under any condition. So the coming back to your recommendation is for a fine until the pole is removed.
Correct.
Okay, and that would begin how soon?
Today.
Today.
Yes.
Okay. Is there anybody? I see some people in the audience who appear to want to testify. Is that correct? Please state your name.
My name's Robert Plasek.
Mr. Plasek, if you could step up to the mic and state your name and address.
Okay, my name's Robert Plasek. I live at 724 First Street South, Jacksonville Beach, Florida.
Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You
can
proceed.
I have some questions, but you can proceed
Okay, I'm
first.
sorry. My understanding was I thought that she wanted fines to be starting. She wanted to give us 30 days to have the sign down would be determined at this hearing. I didn't know we had 30 days to have the pole down, or it would have been down.
That's correct. And nobody said anything about when the pole had to at the last hearing. I agree with that.
Okay.
Okay. So what else is there?
Okay.
Anything else?
No, ma'am, nothing else. We agree with it. The pole's got to go, and we're in the process of doing that. I've got a couple of design things that I have to get with the city to see. A monument sign, I can show you a picture from not that angle looking down that will show you that from the front edge of that chimney to the back edge, to the edge of the sidewalk is 9 feet. So a 4 by 8 foot sign, which is what we had before, centered in that opening, leaves 1 foot on each side from the edge of the sidewalk to the edge of the thing. I don't know that a monument sign could be framed to fit within there.
Well, you can have a smaller monument sign.
Okay, yeah, right. Yeah, we could. We could even have larger, with the and be code compliant with the square footage and fit in between there. But one thing that's going to happen with that, there's I have all the code with me. I didn't bring with me. There's a provision that no signage should block view of pedestrian action. Okay. If you can back up to where the pictures of where all that right there, that's the north entrance to the parking lot of a strip mall right there. So anybody coming out of that driveway will not be able to see pedestrian traffic at all on the sidewalk from past. I mean, if you wouldn't mind taking a look at my telephone, you can see exactly what it looks like at that alley.
Have you provided the picture that you're talking about? Have you provided that to the city?
I have not. I was going to bring it to you just to show you, because last time I got upset just about the angle looking like there's a lot of front yard up there. There's not. That's not.
Well, I'll look at this. I will look at the photograph provided you provide it to the city. However, it doesn't change the fact that my order is going to be for you to remove the pole.
Okay.
And what you and the city decide to do about the new monument sign is outside. You know, I allowed for you to have this discussion. Now's, to bring any kind of evidence to talk to the city for the last 30 days.
Yeah.
It doesn't sound like anything happened.
No.
There was no discussion. And so I'm not going to give you any more time or my order's not gonna address what it is that you're gonna do in the future.
Okay, just
But the
get the
pole
pole
has
down.
to come down.
Yes, ma'am.
Now, I would like to give the respondent 10 days to remove the pole. There's no reason, it's one pole,
Right.
it seems like it can be removed.
How-
I'd like to give him 10 days. Ms. Beavers, if that does not happen, then I'd say that you have to come back and tell me that it doesn't happen.
Okay.
And the $250 day will be retroactive back to the, whatever the 10 days from now is. Can you, Madam Clerk, can you tell us what 10 days from now is?
That would be July 6th.
Say again,
July 6th.
August 6th?
Oh, I'm so sorry. Yes, August 6th.
I know,
Yes.
it's hard to believe July's already virtually gone. August the 6th, is
Is
that?
that 10 business days, or that's not, 10 days from today would be August 2nd?
Correct. Yes, ma'am. That's business days.
Yeah, we're doing 10 days.
Fine.
Fine.
August the 2nd. What day of the week is that?
That is a Saturday.
Okay, let's make it
The 4th.
the 4th. That's a Monday.
Okay.
By midnight on August the 4th, the pole needs to be
The
removed.
sign will be gone by the start of next week. The pole will be gone.
Okay, that's
All
good.
the concrete, all this stuff.
Okay,
So
I think,
you're stating, Your Honor, that if the pole is not removed on August 4th, then the fines will start on that day, or are we
well, they
going
would
back
start
to
on,
today?
they would start on the 5th because he's
Okay.
got all day on the 4th,
Right,
no later than August 4th.
gotcha,
He's got all day, so any fines would start on August the 5th.
gotcha.
And you would need to come back to me
On the 27th.
on the 27th.
Okay.
Okay, Mr. Plasek,
Yes, ma'am.
thank you for being here today.
Thank you.
I would encourage you not to remove the pole and work with the city on finding a sign that you feel will be helpful to the business.
We will, and I can work within the.
Okay,
code.
Okay, thank you very much.
Thank you very much.
Okay, you're
Not
welcome.
see me on the 7th.
Okay. All right. Your Honor, that concludes all my. That concludes all my cases for today. Oh,
There's another case on the agenda.
yes, we're gonna postpone that one until the August 27th so that the property owner will be properly serviced.
We had a notice issue, so we're gonna
It did
continue that one until the next hearing.
at the next hearing.
Yeah.
Okay, I was like, this is a lot. So, but I did get all the different codes and, I felt halfway prepared. Oh, are we on the record? Miss Ireland, are we on the record or do?
Yes, yeah, that's fine. I just wanted to ask you before we end, we started this new procedure. I know you got an email from Mr. Popoli. Our goal is to provide you with as much information up front as we think is going to help you. So if you have suggestions, it's new to us. We've never done it this way before. So we're trying to follow the same process we do for our planning commission, board of adjustment, city council, CRA, etc.
I do think it's better.
Okay, good.
I would ask one other thing. I think it's important for the whole record, and that is that to be sure that the notice, the information about the ownership and the notice is the very first thing that Ms. Beaver should ever say and talk about. The notice
did the staff report, yeah.
was provided when, and therefore it meets
So
the
the
requirements.
timeline is actually in there, in the memo, the dates. Can I approach?
Oh, yeah, on the back side.
Yes,
Yep.
that's the timeline of when all the violation notices, all the inspections, the notice of hearings, everything is in that timeline from the beginning of the case.
So the notice of hearing in this, let's just use this as an example,
Mhm.
was issued on June 25th. And was that for all of the,
Every single thing from every inspection, every notice of violation, the notice of hearing, all of that is in that timeline. Every single date.
it's in the timeline, but I don't have the actual document.
Okay, so if you want the
So,
actual document, I can
Then
provide
I
that
would
as
be
well.
able to track, okay, in this notice of violation, it says the violation is of 34 dash,
Yeah.
the one we just did, 450. And
Because the violation is the same thing that is going to be on the notice of hearing.
so in this one, I don't think that that's part, I've got a lot of photographs, but I don't think that I've got an actual copy of the actual.
That one is the one that we're going to postpone till
Yeah.
the 27th.
Right.
So I can provide the notice of violations and everything when we come back on the 27th.
The notice violation should have been attached. It's a very long,
Okay.
lengthy thing. What we didn't have was a notice of hearing.
Hearing,
That's the one that we failed to provide, so that's why we're asking to continue it. It's about 8 pages.
I didn't. Maybe it's in there. I don't.
Yeah, that one was pretty lengthy. But if you're good with kind of how we're moving forward, any
Yes,
improvement suggestions you have,
I am.
please let me know. Feel free to email me later, even if you think of something, because we're trying to make it easier, not just for you, but for us and for anyone that's been issued a violation, so that they have a better understanding and to get that information to everyone as soon as it's ready and not the day of.
Right. I do know that sometimes it's hard to tell what with the notice of, even though it says it's a notice of violation, sometimes it's hard to understand what exactly is the violation.
It says with it. So on the notice of violation, I can show you a copy of one. I have one with me. Sorry.
I mean, for instance, it wasn't included in any of the sign ones this time.
No,
Not
so
this time.
I don't. I just have because I have the dates on there. But if you want an actual copy of the actual violation notice, I can show you. They say the exact same thing as the notice of hearing.
Yeah, let's take
I
a
think
look
part
at
of it
one
was
real
when we
quick.
went through the stuff that you have, Nikki, for yours that has everything listed on the agenda. We changed that, Elise and I, so it is just like a heading that says this is the violation, and then the notice on mine was attached that had all the details.
Yeah.
Because that way the agenda is not 8 pages.
Gotcha.
So yeah, that may be.
It's in the report.
That section
Was
so
right.
Yeah. But we'll work on
Yeah,
tweaking it so it makes sense.
We'll continue to make it as more clear as we move along and make improvements to the
I do think
each memo.
it's much better.
Good.
And
Thank you.
these are all notice of hearings, but I don't have the notice of violation.
Yeah, and just make sure when you're writing up your notice of violation that there's something that says specifically, that the sign, the sign is damaged and is no longer legal non-conforming and must be removed. And the fact that you haven't removed it is the violation. I mean, it's very straight, clear, one line, some along
Well,
those lines.
normally in the notice of violation, so say if it was overgrown, in that, right above the violation notice, it states front, side, entire property is overgrown. It specifies exactly. So if it's a junk vehicle, it states that the junk is considered a junk vehicle because it has an expired license plate.
Right.
So it is detailed in the violation notice so they know exactly, okay, what debris is she talking about?
Good.
The debris in the backyard.
So that's
Yeah.
that's very good. If it does
Yeah,
that.
so it is in
It's
the
in there.
violation notice. And then I also place door hangers, and I take pictures of the door hangers. So the door hangers, before they even get the violation notice, it's a door hanger that's left at the property that also specifies what violation is and how to remedy it. So they get a couple of things to know what they're being cited for included with the violation.
Right.
So yeah, they do. But I can provide pictures of each one of those if you want all of that as well.
I think if it's in the notice of violation, Ms. Beavers,
I'm sorry.
if it's in the notice of violation, it clearly stated in the notice, that's good.
Okay.
Okay, well, then, we will continue the, case number 24-217 to the August 27th hearing. And, this hearing is